They'll have to
There's a
hear
turn
you.
on the video though.
There's
Mr. Burnett, I saw you're connected. Good morning, Ms. Sicharan. Are you there? Hello, good morning, Ms. Sicharan. Are you there?
Yes. Barbados. Hearing of CCJ Consolidation Petitions in BBCR number 3 of 2019 between Rohan Rambarran and the Queen, and the BBCR number 4 of 2019 between Gavin Wayne Green and the Queen. A 5-member panel sits today comprising their honors, Mr. Justice Saunders, President and the presiding judge.
Good morning, Council.
Mr. Justice Witt.
Good morning, Council.
Madam Justice Rajnat-Lee.
Good morning, Council.
Mr. Justice Barrow.
Good morning, Council.
And Mr. Justice Jamada.
Good morning, Council.
May we have the appearances, please? Thank you very much.
Good morning. I am Richard Cheltenham here at Chambers, White Park Road, Bridgetown. And with me is Ms. Shelley Sisharan. And we appear for the appellant Rohan Rambarran.
Yes, is there an appearance from Mr. Green?
Good morning, Your Honors. My name is Marlon Gordon. I appear on behalf of the applicant, Mr. Gavin Wayne Green.
Yes.
Good morning, Your Honors. My name is Crystal Delaney, and I appear on behalf of the respondent. And with me is Mr. Neville Watson and Mr. Rudolph Burnett.
Okay, thank you. Good morning, Council, all again. And,
Good morning.
As the Deputy Registrar indicated, when you are not speaking, we would ask you please to mute your microphones so that there is very little disturbance on the audio. Mr. Cheltenham, are you ready to commence your submission?
Yes, and may I indicate that Ms. Sisharan presents.
Yes, well, thank you. Ms. Sisharan, you may please
Grateful.
proceed.
Your Honor, lost it. Your Honors, we must start by acknowledging that this matter has a long and convoluted history. Most unusually for a criminal appeal, this is the second time we appear before this court. The trial of this matter took place 11 years ago and lasted about 14 weeks. It has generated 6,000 pages of transcripts and 6 full bank boxes of documents. It has occupied the time and attention of a dozen attorneys. Our client, the applicant in this case, Rohan Rambarran, also spent 10 years in prison, during which time his appeal was not determined. He was subsequently released in 2019 on the basis that his sentence was too harsh and unjustified, and that his appeal had languished for too long. As you know, Your Honors, this morning's application is for special leave to appeal against the decision of the Court of Appeal of Barbados. But with your permission, I do not propose to address in my oral presentation this morning the law as it relates to applications for special leave. We have instead in our written submissions, which we continue to rely on, addressed that matter. With your leave, I propose to address the grounds of appeal, which we propose to argue in this application. And I would wish, Your Honors, with your leave as well, to deal first with the 2 shortest arguments in this matter. The first of which is proposed ground number 2, which deals with the certificate of analysis in this case. I don't think he's speaking. Can you hear me? Yes, okay. I can't. Oh, he's muted.
We can hear you, and you can proceed.
Sorry, I was muted. We are hearing you. I'm hearing you
Yes.
very well.
Good. Thank you. Thank you, sir. Your Honors, it is our respectful submission that a reading of Section 132C to E of the Evidence Act of Barbados makes it clear that there is a statutory procedure by which a certificate of analysis is arrived at and entered into evidence. We have addressed this record of appeal at paragraphs 44 to 48 and 99 to 106 of our submissions, as well as paragraphs 34 to 48 of our submissions in reply. It is our contention, Your Honors, that a careful reading of Section 132 sets out a step-by-step process which takes us from samples to certificates based on samples. We submit that it is incorrect to say, as the Court of Appeal has done in this case, that a failure to follow any of the steps prescribed by Parliament can be treated as technical or merely procedural in nature. It is our contention that it is clear that each step prescribed by Section 132 is dependent on the completion of the preceding step, and the result is a certificate of analysis which is then tendered into evidence and relied on as part of the Crown's case.
Counsel, Counsel, may I have your assistance here?
Yes, sir.
Given that there was oral testimony by the maker of the certificate, giving direct testimony as to what was contained in the certificate, of what significance is the certificate in those circumstances?
My Lord, Your Honor, in this particular instance, we had a reliance by the Crown not simply on oral evidence of an expert, but we had a certificate of analysis which gives the applicant in the case notice of the case that he has to meet. There was no statement, for example, that was tendered, no witness statement that was tendered on behalf of the analyst. What she had was a certificate of analysis, and it is our respectful view that she cannot give evidence in the absence of that certificate of analysis in accordance with the provisions of Section 132.
But Counsel, can you really come with that at this stage? She has given evidence. The jury heard it. They acted upon it. There is not any objection taken that she ought not to have been permitted to testify as to what her conclusion was upon examining the substances.
There was, my Lord, objection to the certificate itself about which she testified and on which her evidence was based.
I am very clear on that. But what I am raising with you is that that testimony, that certificate is in fact overtaken by the fact of the oral testimony.
Respectfully, Your Honor, I cannot agree with that view.
Well, then I will be humble and keep my observations to myself.
But I'm grateful to Your Honor for raising this issue. And the reason that it is important is because when we look at Section 132, it provides a clear procedure by which the evidence of the identity of a controlled substance comes into evidence in a criminal case. And the reason, Your Honor, that we say that the certificate of analysis, not just the expert testimony, is important is because it triggers a reverse burden of proof in accordance with Section 42 of the Drug Abuse Prevention and Control Act. And with respect as well, Your Honor, when we look at Section 132, and this is why we say that this particular procedure was important, not just her oral evidence, but the certificate as well on which her evidence was based. It is clear that Section 132C, specifically subsections 2, 3, 4, and 5, represent a statutory procedure which we say is absolutely mandatory. And with your leave, Your Honors, I would just wish to briefly identify the steps that we say Section 132 requires. The first step is the taking and weighing of a sample by the police in the presence of the accused and the justice of the peace. The second step is the securing of the sample in a wrapped and sealed container. The third step is the signing and initialing of the container by the police and the justice of the peace. Step 4, and this is important, says that where subsection 2 has been complied with, and that subsection 2 sets out all of these requirements, the police officer who took the sample shall sign and date a certificate, render it along with the sample to the Commissioner of Police. The fifth step then is that the Commissioner of Police shall refer the sample to an authorized analyst. And the final step is that where an authorized analyst has made an analysis of a sample referred to him under subsection 4, he shall sign and make a report to the Commissioner of Police. Your Honors, there are then additional requirements with respect to that certificate, including that it should be given to the defendant in the particular case within a specified period of time and so on. It is our respectful submission that the language of Section 132 and each of the steps required there is mandatory, and we reject, therefore, the Court of Appeal's view that the breach in this particular case was merely technical and, apparently to the Court of Appeal, therefore inconsequential. The legislature has set out these steps to ensure the integrity of the sampling and testing process, and it should not respectfully be lightly departed from, because it secures the end product in the case, which is the certificate of analysis. We say, Your Honors, that this is very important because in the vast majority of cases of these types, there will be no contest to this type of evidence. And it will go on to form the basis of the case against an accused and potentially his conviction. It is in these circumstances, Your Honors, that we say that the certificate of analysis does not and cannot stand on its own. It is the product of a process in which each and every step is important, because each and every step plays a role in securing that certificate.
Ms. Teacheran, sorry to interrupt you. May I just ask something? I think I follow what you're saying about the statutory regime for obtaining the certificate of analysis. But what I thought our brother asked you was, independent of that, is it possible in a trial like this for the expert, if the evidence demonstrates that the expert took samples in the presence of the appellants, tested those samples that in this case she said she took, can that expert come into the witness box and give viva voce evidence as an expert of both that process and her findings and or verification? Or are you saying that that is not possible given Section 132?
That is our position, Your Honor, because there would be no basis then.
Sorry.
There would be no basis that the certificate of analysis and the expert's testimony have to go together, and that she cannot testify independent of the certificate of analysis, because then an accused would have no notice of the case that he is being asked to meet. There is no statement which is really taken from the analyst in this particular case. What you have then is a scientific study which results in a certificate of analysis, equivalent in many cases to an expert's report.
But if you say that here, if the nub of your argument is that the accused did not have notice of the case that he had to meet, didn't the certificate, even though it may have been flawed, but didn't it bring home to him what was the case that he had to meet?
But that's the point, my lord, then, is that the certificate therefore cannot stand by itself, because that is, yes.
let us, for argument's sake, accept that the certificate is flawed.
Yes.
What I'm saying to you, and what my two colleagues have been suggesting to you, is that quite apart from the certificate, the analyst herself gave oral evidence of what was contained in the certificate. Now, as I understand it, your difficulty is that that oral evidence is somehow not to be given any weight because the accused would not have had a witness statement, or the accused would not have been able to understand the case that was being made against him.
Yes.
But can you properly say that when the flawed certificate was given to him? Do you understand what I'm saying?
Sorry, Your Honor. Let me ensure that I understand the court's question here. Essentially, the court is asking whether or not she can give oral testimony independent of her certificate.
There are two things going on here. There's a certificate, which you say has to go through a particular procedure, and you say that that procedure was flawed.
Yes,
but
sir.
My brother judges said to you, well, okay, even if that was flawed, the expert gave oral evidence, which therefore did not require any certificate. Your response to that is that, but this oral evidence did not, your client did not have any forewarning, so to speak, of what was going to be contained in this oral evidence, and therefore the oral evidence should be disregarded. Isn't that what you're saying to us?
Yes, yes, sir.
And I am saying to you that if that is what you're saying to us, then even if the certificate does not have any value as a certificate proving the chemical makeup of the samples, then it must have some value as giving notice to the accused of what the oral evidence was going to adduce.
I understand I understand what you're saying, Lord. You're saying that essentially then, even if it doesn't have evidential value in and of itself as a certificate of analysis, then it would constitute notice in the same way that a witness statement might.
Precisely.
Yes. But I would suggest respectfully, Your Honors, that that cannot be the end of the matter, nor can it be an accepted practice in relation to expert evidence generally, nor can it be an accepted practice in relation to certificates of analysis. We should not lightly depart from or ignore the fact that a certificate of analysis is not intended to be a witness statement. It is in fact intended to be a piece of evidence in and of itself, which constitutes prima facie evidence. Now, the Crown referred at section 50, the Crown referred in its submissions to section 59 of the Evidence Act of Barbados, which says essentially that an expert's report can be adduced into evidence without the testimony of an expert. So if we take that logic about section 59, a certificate of analysis can stand on its own without an expert giving evidence about it. I would argue that the circumstances in which that can or should be done are very limited. For example, where the expert may no longer be available. But I cannot agree respectfully that we can equate a certificate of analysis with a regular witness statement. It is a piece of evidence by itself, and the Evidence Act does treat it that way. And respectfully is, yes.
Counsel, may I help you here?
Yes, sir.
Sir Richard, you will know his reputation. I have had the great pleasure of having him appear as counsel before me. in another court at another time. His standing, his erudition, his command of forensic matters is, I think, almost unmatched. I did not see Sir Richard, reading the lengthy cross-examination of Ms. Skeet, take any objection to her giving evidence as to the identity of the substance. He did not protest that she should not be allowed to give her evidence because there was no forewarning of the evidence which she would be giving. Therefore, it seems to me, but again, I will be happy to bow to your final view. It seems to me that you have absolutely no basis for going any further with this because the evidence is in. There is no ground of appeal that it ought not to have been admitted. And it seems to me that is the end of the matter. But again, I say this with diffidence because you are liable to rule against my view.
Your Honor, my learned senior asked me to acknowledge and thank you for your generous compliment to him. But respectfully, there was in fact a ground of appeal before the Court of Appeal that talked about the fact that the certificate of analysis was admitted into evidence in spite of the fact that the samples were excluded. And
I am not asking you to address on the certificate. I'm telling you that there is the evidence of the expert before the court, and that is what you are stuck with. So my own invitation to you for the present moment is ignore the certificate.
Yes. Your Honors, with your leave then, your indulgence, sir. Yes. Your Honors, on that point, we will continue to rely on our written submission and we will press on with our oral presentation, which is to the effect, Your Honors, that at the end of the day, the evidence of the expert in this case was completely discredited in cross-examination, such that her evidence, whether reflected either in the certificate of analysis or in her oral presentation, could not safely ground any conviction in this case. We have made, Your Honors, a detailed criticism of the expert evidence at this trial. We've set out in great detail in our written submissions, both before the Court of Appeal and before this honorable court, a critique of Ms. Skeet's evidence. With your leave, I would wish briefly to remind the court of the nature of that critique. The first and most serious basis on which Ms. Skeet was challenged was the samples that were taken in this case. And Justice Jamadar did speak to us earlier about the fact that she had taken the samples. But I would wish to draw to the court's attention the fact that the question of who took the samples in this case turned out to be a major dispute of fact. Section 132 of the Act says that samples shall be referred to an analyst having been taken by a police officer. It is for the police officer to take the samples and then send it on to the forensic lab. We had said to the Court of Appeal and to Ms. Skeet in cross-examination as well that the law provides no role for her at the scene. Both Ms. Skeet and Sergeant Hope then testified that it was he, Sergeant Hope, who had taken the samples under her instruction and guidance. The criticism that arose from that sampling exercise.
When you say under her supervision and guidance, was she present at the take-in?
The evidence, sir, is that she was present.
All right, so that it is not disputed that she was present.
Yes.
At the take-in, even if, as you say, the police officer, on her instructions, executed the taking?
It turned out to be, sir, a dispute of fact even as to who had taken the samples in the end, because the police photographer, Sergeant Griffith, whose evidence we have relied on in our submissions to this court, said that he saw Mesquite taking the samples. But the recognized sampler in the case, that is Sergeant Hope and Mesquite, both said that he took the samples.
Who else was present at the taking of the samples?
I think all of the additional police officers, the accused persons, and, well, I couldn't verify the presence of a justice of the peace, but supposedly one was present.
Okay.
But he didn't sign the samples as required by law.
No, that is clear. Who did anyone else sign?
My recall, Your Honor, and I'm subject to correction, is that only Sergeant Hope signed the samples, the actual samples.
Okay. So wait, just a minute. Is it
Charan,
not?
Yes.
Sorry. Yes.
Yes.
This is Rajnath.
Yes, thank you, Judge. Ms. Charan, before you proceed, could you just, for my own benefit, everyone else may know, but under what proposed ground are you arguing about the evidence of Ms.
Yes, I had intended, Your Honor, to just briefly outline the critique of the expert evidence, which relates to ground that deals with the no case submission. I believe that is ground number 1. Sorry, ground number 1. Okay. And then also the ground that relates to expert directions, which is ground number 4. Both of these grounds depend on a critique, an analytical, detailed critique of the expert evidence in this case, because it is our respectful position that the no case submission should have been upheld in this case, because the expert evidence had clearly and demonstrably failed on multiple bases and at multiple stages.
Counsel, if I may be helpful here, trying to be.
Yes, yes, sir.
I think you have an hour for your presentation.
Yes, sir.
I get the sense you're halfway into it already. So it's a question for you, purely for you, whether you want to spend time going over the critique of the evidence, since it is fully in your submission, or whether you want to do the principle. It's entirely for you.
Thank you, sir. Yes, I think it may be useful as a matter of presentation, sir, to just briefly remind the court of some of these critiques. The sampling is one of those, and I'm grateful, sir, to you for your indication that you've read in some detail Mesquite's cross-examination in this particular case. It did take up 300 pages and 3 days of evidence in this case. It was then the subject of a long recital by the learned trial judge in her summation. And very briefly, the areas in which we critiqued Mesquite's evidence at every level, including the sampling in this case, which she accepted, if it were not representative, her entire process would be null and void. But there was this big dispute between herself and Sergeant Hope as to whether or not random samples had been taken or whether every package had been sampled, as Mesquite contended. We complained too that there is no peer review in this particular case. There was a major difficulty with Mesquite's evidence because in the initial stages of the case, she represented herself as the only analyst. She never gave any evidence about the involvement of any other scientist in this case. In fact, it was in response to the learned director of public prosecutions at the time, now deceased, that she said she did the analysis herself. It is only when we get to the cross-examination that we then hear about Miss Debbie Nurse. She's accepted in her evidence as well that peer review is an inflexible protocol, and we say that there was none in this case, and there could be none in this case, because Ms. Skeet had interposed herself as the analyst. The question of who then was the analyst, whether Ms. Skeet or Ms. Nurse, remains a matter with respect of some mystery. We've complained too that there was a lack of reviewable data in this case. Yes, and I'm reminded that if she was in fact the analyst, she could not peer review her own work. We've complained throughout that the evidence in this case is that the sampling and testing process was characterized by sloppiness. This is evidence on which our client got a 30-year sentence. There is another troubling point, Your Honors, in this particular case, and that is a lack of integrity. And this is why we have maintained throughout that expert evidence in criminal cases needs greater scrutiny. There were two areas which demonstrate, in our opinion, a lack of integrity in this case. One is the presence of the so-called post-dated signature of Inspector Bowen. This signature is dated the 28th day of February 2007, which is very conveniently the same date on which the lab repeated two of the tests in this case, specifically the TLC and UV tests. Ms. Skeet offered no explanation for the presence of that signature on the chain of custody document, that is the movement log, which she had accepted 3 months earlier. She accepted in cross-examination that the presence of this signature was an impropriety and a fraud in the process. We say too that the lack of peer review, to which I've just referred, is another example of the lack of integrity that characterized this expert evidence. The question arises when we look at that signature in particular, is were there other samples that were taken in this case of which we don't have any knowledge? And we say that that is the reason that adherence to the procedure set out in Section 132 becomes critically important. It secures the integrity of the process on which people in this country are convicted and sentenced to long terms of imprisonment. But I'm grateful to Your Honor that for the opportunity to just briefly remind the court of what is already contained in our written submissions. Specifically, paragraphs 18 to 74, and then 9 to 27 of our submissions in reply. Yes. In relation to the ground of appeal, ground number 1, which deals with the no case submission, the learned trial judge ruled that this was in effect a matter which fell within the second limb of Galbraith, and the Learned Court of Appeal of Barbados agreed with that view. We have said and maintained and continue to maintain that this was not a matter within the second limb, but within the first limb of Galbraith, where the prosecution's evidence of the identity of the substances, even taken at its highest, is such that a jury properly directed could not properly convict on it. And that if the learned trial judge had made an effort to grapple with this evidence, with its many admissions, concessions, contradictions, she would have come to that inevitable conclusion. We have relied, Your Honors, on the Barbadian case of Bell, which is also a case of technical evidence. It dealt with a medical expert, a doctor in that case, and we say that it is most apposite. Chief Justice Douglas at the time gave a rigorous scrutiny to the doctor's evidence, and he concluded that there was no attempt made in that particular case, as we say, there has been in this one as well, no attempt to come to grips with the evidence as it relates to the issues in dispute. Chief Justice Douglas ruled that had the learned trial judge examined the admissions, the concessions, and the contradictions, it would have been apparent that the medical evidence was in such disarray as to be incapable of supporting any finding on the cause of death. Yes. We commend that approach to this court. Wish to emphasize, Your Honors, that the courts below have treated this matter as though it was a simple one of credibility for the jury to assess. When you deal with IC witnesses, issues of discrepancies and inconsistencies may be matters for the jury to resolve. But this is evidence of a different kind and character, and that is expert evidence, which juries are often not well equipped to deal with. We maintain that this is a case in which the no-case submission made at the close of the Crown's case called for a rigorous analysis, which we say the trial judge failed to undertake, and which we say respectfully the Court of Appeal has also failed to undertake. It is not a simple issue of credibility. And that leads me, yes, that leads me, Your Honors, to another aspect of this case on which a critique of the expert evidence relies, and that is the question of what expert directions should be given. We accept that the learned trial judge in this case gave a direction consistent with the case of Sargent versus R. It is our respectful contention, however, that the time has come for our courts to review and revisit that direction and question its adequacy in light of scientific developments. We note that in giving her directions, the learned trial judge failed to critically analyze the expert evidence for the benefit of the jury, as was required in the case of Bell and also in the case of King and Yard, to which we have referred. Instead, the learned trial judge, we say, simply recited the evidence. But I must remind Your Honors that this was a 14-week trial. Ms. Skeet testified for 3 days on several issues. It is our contention that a recitation of the evidence was simply not adequate, certainly not when it came to an expert. The jury had a right to be directed on disputes of fact. Sorry. Milords?
Yes, go ahead.
Yes. We're saying that the jury had an obligation, had a right to be directed on disputes of fact and to be told what the implications of those disputes were for the reliability of the scientific evidence in this case. It is our contention that that was simply not done, and we disagree most strenuously with the Court of Appeal at paragraphs 87 and 88 of its judgment, where they concluded that a direction on inconsistencies and discrepancies is adequate with respect to experts. We profoundly disagree. We contend that the direction recommended in Sargent is not adequate to meet the state of science today, especially when there is a tendency by laypersons to overestimate the value and reliability of scientific evidence. We have referred this court to several authorities which highlight this dispute. The first is the New South Wales Criminal Trial Court Bench book, which has been updated as recently as October 2007. At paragraph 2-1100, it is recommended that a direction highlighting the disputes of fact for the jury be given. The book recommends too a particular direction, and I would just wish briefly to remind the court of what is said there. It is recommended that a direction be given in these terms. If the opinion is based upon facts which you are satisfied have been proved, or assumptions that you are satisfied are valid, then it is a matter for you to consider whether the opinion is based upon whether the opinion that is based upon those facts or assumptions is correct. If, on the other hand, you decide that the facts have not been proved or the assumptions are not valid, then any opinion based upon them is of no assistance because it has no foundation. If that is the case, the opinion should be disregarded. We have complained at every stage, and we continue to complain that there were major disputes of fact which grounded the scientific evidence in this case, and that was the sampling in particular. We complain that in reading simply in extenso Mesquite's evidence, the trial judge did not provide the jury with any adequate assistance in analyzing the evidence. For example, did Mesquite perform the analysis herself? What are the implications of that for the reliability of the evidence? We respectfully contend, Your Honors, that both the High Court and the Court of Appeal, notwithstanding the recognition that Mesquite was an expert in this case, treated her like an ordinary IC witness. The jury was owed a more appropriate direction. We have relied to, Your Honors, and continue to rely on 2 articles from the Criminal Law Review, specifically Edmund and Roberts' 2011 Criminal Law Review, page 88. We have referred the court to the Law Commission report, Expert Evidence in Criminal Proceedings in England and Wales, and also Drawing on Expertise, Legal Decision-Making, and the Reception of Expert Evidence by Andrew Roberts, 2008 Criminal Law Review, page 443. Your Honors, we say that change is the law of life, and the law has to adapt to meet the needs of an ever-evolving society. This case started 11 years ago, and today in 2020, there is a greater and greater reliance on scientific evidence in criminal cases. It is clear from a review of the authorities that we've presented that the courts in England in particular are grappling with how to treat expert evidence. We say that the time has come for Barbados to revisit the expert direction that is typically given and to expand it so that it is more useful for today's society. I would commend to Your Honors page 451 of the 2008 article by Roberts. He says that the expert evidence is considered admissible on the ground that due to a lack of necessary knowledge, skill, or experience, the tribunal of fact would be unable to draw the inference which the expert proffers. He goes on to say that consequently, it has been claimed that the jury must either defer to the expert and accept his evidence at face value or reject it on irrational grounds. The authorities there go on to consider whether we should now be adopting what they call an enhanced reliability or sufficiency test for the reception of expert evidence. I do not know, Your Honors, that we need to go that far in Barbados, but we say, however, that the time has... Hello?
Yes, we are hearing you.
Sorry, my screen disappeared for a minute. The time has come for us to revisit that direction. We say too that in this particular case, the judge had a positive obligation which she neglected to comply with, to grapple with the evidence and put the implications of all of these disputes squarely before the jury. We say that the failure to do that, Your Honors, in this particular case, represents a material non-direction and a misdirection which has caused our client to suffer a serious miscarriage of justice, which ought to be corrected by an overturning of his conviction. It's striking to me, Your Honors, that in 2020, we have judges, trained professionals in civil courts, receiving greater protection in the reception and analysis of expert evidence than we are offering to lay juries in criminal cases, where the implications are certainly more serious. Your indulgence, Your Honor. All right. Your Honors, with your leave, just wish very briefly to deal with ground number 3, which was the viewing of the bulk.
The viewing of
in this particular commissions, and then paragraph 49 of our reply. Do not think that it is in dispute, Your Honors, that the Crown elected to establish the identity of the substances in this case in accordance with Section 132 of the Evidence Act. That is the taking of samples and then the production of a certificate of analysis based on samples. The Crown's case opened and proceeded on that basis, and it is our submission that only when it became clear that the scientific evidence in this case had failed and had been utterly discredited, that the Crown then applied or sought to admit the bulk in this case.
Counsel, you must not take that as the fact, you know. The Crown has never conceded that their case was utterly destroyed.
Yes, that is certainly the Crown's position, Your Honor. But we say that when you apply, it's unfortunate, Your Honors, that we did not have a videotape of what happened in 2009. And the experts' utter destruction on the witness stand by my learned senior, Sir Richard. I think that unfortunately, the written record only reflects partially what happened, but it is what we have to rely on. Your Honors, we have relied on several authorities in this particular case, which demonstrate very clearly that the identity of a seized substance is not a matter which ordinary eyes can decipher for themselves. We've referred to the case of Chatwood. We've referred to Mears versus Rees. We've provided to a copy of Narcotic Offences by Rinaldi and Gillies, page 214, which states that there was an admission by the appellant in that particular case that the substance in his possession was marijuana. According to the court, however, there was not in this case, as was required by the authorities, a sufficient basis for the expression of that opinion by the accused. No sufficient basis of knowledge and experience was established, and it would not be safe to act on his admission, no evidence having been tendered concerning his familiarity with marijuana. We've complained that the admission of the bulk in this case was purely prejudicial and that any probative value that it had was outweighed by that prejudice. We say that on that basis, the evidence should have been excluded in accordance with Section 115 of the Evidence Act. It was accepted even by the analyst in this case that what she referred to as visual inspection is only intended to assist in the sampling process. But there can be no safe or reliable inference or conclusion drawn from simply viewing it, and that was not made clear to the jury in this case. You cannot look and see, unfortunately, in a matter of this kind. It's a matter of analysis and of proper science. And we say, of course, that there has been no proper scientific methodologies observed in this particular case.
Of course, drug users don't need that analysis.
So,
drug users they don't need that analysis. They know it immediately. Of course,
well,
I'm not saying that the jury were drug users, but
yes.
But it was not contested that what was shown, that bulk that was shown, it was not contested that was what was seized by the police.
No, Your Honor, it was not.
Okay.
But I would, as Your Honor mentioned it, what's interesting about the cases that I've referred to, including the case of Mears versus Rees, it demonstrates that even experienced drug users can be deceived about what they're looking at. And even in those cases where there's been confession evidence, it's not reliable enough. And with respect, it is our position that these are now matters which indisputably have to be dealt with by scientific evidence. And in our reply, we have referred to, or rather analyzed, two cases provided by the Crown, the cases of Labine and Grundwall, which come out of the Canadian courts that deal with that dispute. Is this a matter which can only be now safely determined by scientific evidence? What's interesting about the line of authorities where there was evidence other than scientific evidence, there was some additional buttressing evidence about the experience of the person who made that statement, but there was no experience in this case either by the accused persons or by the jury themselves. It then falls to be determined on the basis of scientific analysis. And it was the case of, I believe it is Grundwall, where the Alberta Court of Appeal says that invariably that is the approach that should be used. And with your indulgence, I think I'm going to end it. Yeah. Just about. Your Honors, with your permission, the applicant Rambarran will rest here and continue to rely on our written submissions.
Okay, thank you very much, Ms. Sichuan.
Grateful, sir.
Yes, Mr. Gordon.
Good morning again, my lord.
Yes, good
Your
morning.
Honor, my difficulty as is I have my stuff, everything is online, so that.
You want to plug into my computer? If they give us a minute, I can use this one.
Could my lord, Your Honor, all of my work is online. So that the sticking over with my teacher a while ago, I would have to now reconstitute my.
Okay, you go ahead and do what you need to do to be able to make your submissions.
Yes, can you join us?
Do you want to use this laptop? Use this laptop and let them use his. Okay.
Can you see me?
We are seeing you fine.
Very well. I can't see you because my screen is
I
off.
appreciate that, but we are seeing you fine, so that's okay.
Very well.
And we can hear you too.
And you can hear me. Very
And
well.
we're hearing you just fine.
Very well. Now I will start, my lord, Your Honor, sorry, by relying on the submissions that were filed on behalf of Mr. Green. The complaint that we have made it relates to the fact that the applicant Green had filed 2 grounds as it relates to what was the warning in the Barbados Court of Appeal that the trial judge had given as it relates to the co-accused Christopher Bacchus' evidence.
Right.
And also the adequacy of the warning under Section 137 of the Evidence Act, which relates to oral evidence. We were not able to get a decision on those from the Court of Appeal. And I believe, sir, one of the issues that I must address you on is that if the Crown made the concession that there was no decision, then obviously there must be some way that this court would be put in a position to render a decision on that, because of the reality is when a man makes an appeal against his conviction, it is for the Court of Appeal in Barbados under Section 14 of the Criminal Appeals Act to say whether they find that the conviction is safe and satisfactory. So in light of the fact that he got no return on that, we're saying that this court would be in a position to review what the trial judge's warning was and to say whether it was adequate in the circumstances. In the Court of Appeal in Barbados, I believe we took a little bit of a liberty at the time because we had cited some cases such as Loban out of Jamaica, Gunwardine, which is basic principle involving whether the co-accused evidence properly, so to speak, can incriminate the other co-accused. We acknowledge, because of the lengthy amount of time that was spent in the trial process, and I believe on the record it is replete with Sir Richard starting out, especially as it relates to what was said about his client in his having given his evidence, so that we know that the issue was a very contentious matter. My humble view on it was that when Mr. Bacchus brought his sworn statement, there was nothing to prevent him properly. That is his defense. And he was entitled to put his defense. But the warning must recognize that he was not just a person who had an interest to serve. If it is that his interest to serve is there, normally it will be suggesting that he was helping the Crown. In this case, it was no such thing. He was incriminating himself and others with him. In the past, when these rules were developed, it was normally to provide some balance to say that this person, he's trying to throw blame from himself to cast on the other person the blame. But what happened in this was he cast the blame, giving us a defense in his regard, putting himself involved and putting Mr. Green, whose defense was that he never knew any of his co-accused, and the only time he met them was when he was brought back to Mr. Bacchus's house.
But Mr. Gordon, if I may, did you represent Mr. Green at the trial?
No, Your Honor.
I see. Didn't counsel for Mr. Green have an opportunity to cross-examine Mr. Bacchus?
And he did, my lord, Your Honor.
Well, so then what, I don't understand what is the difficulty that you're having?
Well, the cross-examination is at that stage, sir. And I can say my finding on that, when Mr. Watson asks of Mr. Bacchus, it is at this record in this court, page 5163, and it continues up to 5164, he agrees that he never saw Gavin Green on the 28th, but then he said he saw him on the 30th. And then he said that the police took him to the back door. In as much as if he saw him and put him on an occasion, it doesn't necessarily mean that he was involved in any other dealings that involve anything with drugs. But that by itself is not enough. We really want to be in a position to say what would have been the judge's duty. And we're saying that the summation, if we had the record in a video format, we're saying that the judge's summation was merely a repeating of the evidence. There was no effort made to analyze, assess, evaluate, and give the jury the guidance that they would require, because obviously the jury are not trained to decipher when a man makes such a compelling statement against his co-accused to say that is not able to prove the case against the person who is saying was there. Right throughout the judge's summation, it was said, she said, I must warn you that you must examine the evidence with particular care, for the accused Bacchus in saying what he's saying may have been more concerned about protecting himself than about speaking the truth. But he wasn't protecting himself, my lord, Your Honors.
Just remind me what page of the record you're reading from, sir?
That is from the summation volume.
What page?
It is on the summation, which I believe it will be page 17. It's on Miss Ciceran's filing. I didn't file that part. I filed the full e-record, but that part of it was not. But it would be 17 on the hard copy, but on the trial record for your court, I believe it's page 17, I am told by Miss Ciceran.
Thank you.
And that, I crave indulgence, Your Honors. Right. So that was what she said. I must warn you that you must examine the evidence with particular care, for the accused Bacchus, in saying what he did, may have been more concerned about protecting himself than about speaking the truth. Bearing in mind when deciding whether you can believe what the accused Bacchus, Mr. Christopher Bacchus, told you about his co-accused. Having given you that warning, Mr. Foreman and your member, you must assess the evidence of the accused Christopher Bacchus by the same standard as you evaluate and assess all the other evidence in the case. It kind of brings me to the point where the Crown, in their response to my challenge to the warning and the quality of it, we're more interested in saying that we were trying to hinder Bacchus's evidence because it's right under Section 10 of the Constitution. That was repeated by Mr. Leacock to give his defense. Ms. Pyle, who was his lawyer, was also of that view. So I don't think that anybody who was prepared to say that if that is his defense, it is his defense. But the judge have a duty now to guide the jury that his defense cannot undermine the rest of the parties in the trial's case.
But I don't understand that. Doesn't he have a right to give whatever testimony he wishes to give?
We can't curtail him, my lord. Your Honor, I don't believe that he can be curtailed in any way. I accept that he has this right to give the evidence that he wants. But how do the judge direct the jury on that in a case where he's making very incriminating remarks against himself and incriminating others? In the ordinary cases, it is normally he's casting blame on others and exculpating himself. But in this case, he's carrying himself down and carrying down everybody with him. So the warning to the judge would have been improper. It would have been almost to say that you take this warning now, that he was protected. How was he protecting himself when he was carrying down the whole ship? In fact, it was like a lightning strike in the trial process, because I had the benefit of being involved in it from the magistrate.
Counsel, what would you suggest the judge should have said about this? What do you suggest?
I'm losing you a bit there, my dear Honor.
Say the judge should have said, in your view, what the judge should have said?
The judge would have been required to inform the jury that the evidence can only incriminate Mr. Bacchus.
No.
It cannot incriminate.
No, Mr. Gordon.
I'm sorry.
That is if he were making an unsworn statement. But if he goes into the witness box, isn't all of his evidence to be treated by the jury in the same fashion that they would treat all the other evidence of persons who have given sworn testimony?
But Mr. Bacchus gave his evidence, and Mr. Green gave his evidence too, because the unsworn statement in Barbados is considered evidence that has to be treated in the same way.
We're talking not about unsworn evidence now.
But you were asking.
Mr. Bacchus gave sworn testimony, isn't that correct?
Yes, Your Honor.
And in his sworn testimony, you say, and it was the case, that he not only implicated himself, but he implicated other co-accused. Is that correct?
Yes, Your Honor.
And you're saying that he ought not to be permitted to implicate other co-accused?
Never said that, Your Honor. I'm saying that the judge would have to direct the jury that it is his evidence. But in the care that she's saying that they must be concerned about protecting himself than about speaking the truth, it is almost at odds with his testimony, but it was something more was necessary for the direction to be effective.
And what is that more again?
That it is not evidence that can incriminate anyone other than himself. It is his evidence.
Do you have any authority that suggests that when one co-accused goes on the witness stand and gives evidence against other co-accused, that evidence that implicates the co-accused ought not to be considered as evidence against the co-accused? Do you have any case that says that?
In our submission, we had cited the case of R.V. Gunwadeen, a 1951 case, but we know the law has moved on some more from there. But it was held there that a co-accused make a statement which implicates his other co-accused. It is vital that this judge emphasized that such statement constitutes evidence only against the maker and not the co-defendant.
And that is the statement that is referenced there. That is testimony on oath, or is it simply a statement given to the police?
Well, that is the problem, where he went in and gave sworn testimony. So it would
no. The case of Gunwadeen.
No, that was an out-of-court statement.
But this is the point. How can you conflate an out-of-court statement and seek to rely on the law that relates to an out-of-court statement with a statement given, well, not a statement, with testimony given on the witness stand before the jury?
Well, the other cases which we had cited, my lord, and it was in paragraph 25 of my submission, Regina versus Shima, it was held that there was no rule requiring a full corroboration direction for a co-accused evidence to be admitted. The court recommended a review of the law, and it was said by Lord Taylor, the rule of practice that some warning, but not necessarily a full corroboration warning, is required, where a witness, example, a co-defendant may have a purpose of his own to serve, and this was affirmed. But okay, we acknowledge that the sworn statement as is evidence in court is different from an outer court statement, but the efficacy of a direction to the jury, where the parties are, in a sense, co-accused, or in this regards, one would say accomplices now, because his evidence is generally tending to be an accomplice evidence. You can't just leave it to the jury to say, I've warned you. Why should you warn the jury? What is the warning about? You have an interest to serve, but you have to go into the exact reason, what is his interest, in light of the fact of Mr. Christopher Barbados' assertion that he never knew these persons. He only met him at the time the police brought him back to his house. He was on the street. The court properly said that he had raised the issue of an alibi of sort and how to treat that. But at no time did the court make any effort to say that statement, or not statement, that evidence is not corroborative of anything against anyone.
Counsel,
Mr. Bacchus.
Counsel, you need to help me here.
Yes.
I'm looking at the ground which I think you began arguing, which was ground 1.
Yes, sir.
That the warning given by the learned trial judge regarding the confession of Christopher Bacchus was inadequate as it relates to the appellant. The warning failed to properly advise the jury that the confession of Christopher Bacchus was not evidence capable of incriminating the appellant and was only incriminating against Christopher Bacchus. That is the ground that you have before us.
Yes.
And it seems to me that arguing about corroboration and so on is not about this ground.
Well, no.
Counsel, allow me to finish, pretty please. The ground is simply whether it was evidence that was admissible to found the guilt of Green.
I have serious difficulty with it being allowed to go to that point, in as much as it is sworn testimony and it is Green's defense. The warning itself wasn't, to me, adequate.
Which warning?
The one I must warn you that you must examine the evidence of the accused Bacchus in what he's saying, that he may have been more concerned about protecting himself.
That was guidance to the jury as to how to view Bacchus's evidence for the benefit. This is a warning, as it were, given for the benefit of Green. But the admissibility, counsel, the admissibility of the evidence against Green is your ground. So once you concede that it is admissible as against Green, then that means your ground cannot succeed.
But how would it be able to incriminate Green in circumstances in as much as it's sworn testimony when Mr. Green is saying that my defense, I wasn't there?
Because somebody contradicts Mr. Green. That is Bacchus. Bacchus contradicts Green by sworn testimony. The question is, who will the jury believe? But in law, and this is a point the president was making, in law, the jury are entitled to rely fully upon Bacchus's testimony to find Green guilty. They are entitled to do so. Not that they should, not that they must.
But in as much as they are entitled to do so, what protective mechanism in a trial process will their court use? The judge will just say, you must just take care. I don't know that is the fair standard that the law provides, and I believe that there were some efforts to highlight some of the issues that has been around that point. I know I was a little bit late in some of my finishing up this submission in response, but I was able to find one case out of Jamaica which wasn't cited to you on that point, and it was a case involving, what's his name, John. I'll try and find it on my...
But tell me, what is the principle of the case?
I have it, my lord. I'm just trying to find it on my system. It's in the other section. Okay, my lord, indulgence. Number 2. It was in a case involving some issue of, because, yes, my lord, it is admissible and the jury are entitled to act on it. But is it independent evidence that can say it prove his guilt on its own? I mean,
but if the jury believes it, let's go step by step. You admit that it is admissible evidence.
Yes.
If it is admissible evidence, then it is properly before the jury, and the jury is entitled to consider it. If when the jury looks at Mr. Bacchus, here's Mr. Bacchus, here's the cross-examination of Mr. Bacchus, and says to themselves, we believe what Mr. Bacchus is saying, then what is wrong with that? I agree with you that the judge should give an appropriate warning to the jury, because Mr. Bacchus may be simply trying to shift some or all of the blame to his co-accused. But for you to say that the jury, allow me, for you to say that the jury, or to imply, was not entitled to consider Mr. Bacchus's evidence as evidence of the guilt of Mr. Green, I don't know of any case that says that.
I'm not saying that, Your Honor. I'm just saying that in terms of what the warning she gave, it was at odds with what actually was, in fact, what was the issue between the parties at trial. It was that he was deflecting from himself and saying things that were making himself look good and the others look bad. So the warning that she gave would have had to be more than just to say that he was protecting himself.
What is the warning? Well, I want you to answer the question. It has been asked before, but I think that the answer that you gave did not quite comport with the law which you have since agreed. What is the warning that should have been given?
Well, the warning she gave was the warning that was required, but the strength was not enough in the context because of the facts and the whole issue of what happened in the trial process.
Okay,
because
so
we're
making a lot of progress. You've agreed that the evidence was admissible. You've agreed that the jury could consider it and could use it to base their finding of guilt. You have against Mr. Green. You have agreed that the warning was what should have been given, but what you're saying now is that the warning should have been stronger. Stronger
Yes.
Stronger in what way?
In terms of the scale of reliability that can be placed on it to put Mr. Green at peril because of what was said by Mr. Bacchus. No guidance was given by the judge on how to treat. I mean, she said that he had an alibi, and when we look through the case, the police evidence in this case was largely based upon a confession and the seized substance found at Mr. Bacchus's house. Right throughout the entire trial process, it is replete from every accused that they were beaten. Not that is the complaint we're making now, because that's a far different argument. But in light of what was the general tone, tenor of the case that was totally at odds with the case that was being presented before the jury up to that point in time. So it would have, it is easy to guess, and like it is a discretionary point to criticize the judge. But at the end of the day, it's a facts sensitive issue where the discretion for it to be properly applied and to be treated in the fashion that the law would say give the accused the chance of his case being treated, because in as much as they were being tried together, the reality is that it was each man was separately on trial. And even the director was at one point during the first round of dispute, when the issue with Sir Richard arose about Mr. Rambarran, the director said he had a case previously where that, and he can concede that it was not a cutthroat defense.
Mr. Gordon, 3 judges have asked you a question which you have still succeeded not answering. The question is simply that you say, well, the warning was not good enough, it should have been stronger. So the question is, what should the judge have said? And up to now, I didn't hear the answer.
She should have really not just gone, she should have gone to highlight the warning by saying that it is not independent evidence against Mr. Green. It is his defense. He has said that you're entitled to believe him, but it's not independent evidence that you can use to convict him on his defense. That is Green's defense.
But surely there was more evidence than that.
So that it is not able to independently verify Green's participation in any enterprise involving himself or with the others. The case I was trying to explain to you out of Jamaica was on a totally different point. But what was said in that case in John Hall, at the very end, the citation, it is not in this bundle, but in reading and preparing for it, there was a rape case where the VC had made some notes. It's reported that 2011 JMCA Crim 51, Criminal Appeal number 107 of 2006 for Justice Harris, Justice Dukran, and Madam Justice McIntosh. The virtual complainant had made some written notes about the incident which she said had happened, and she had relied on that as part of her evidence, which was an oath to say that, this would verify her account. And in this case, the whole issue came up with the warning and what discretion and whether it was, because they cited Macanjola at the end. But at the very end of the decision, the court at paragraph 33 said this: we will now direct our attention to the case under review. The learned judge correctly directed the jury as to the meaning of corroboration and warn them of the dangers of acting on the uncorroborated evidence of the complainant. They look at the discrepancy, but there was no independent evidence to show what she said she had written down was in fact true. So this would give rise to the danger that the jury could have entertained the belief that the complainant evidence buttressed her credibility. So that in as much as Mr. Bacchus, it was a credibility issue where the jury would have to believe him versus what his co-accused said, or believe everybody. But it would have been very difficult for the court not to have said that did not buttress the case that the Crown had against Mr. Green, because Mr. Bacchus' evidence tend to show or put him on the scene in spite of his defense that he wasn't involved and was not there and was only brought back. So the warning would have to be strong enough to say that it was not in the circumstances, was not able to independently bring the case against Green to the standard that the jury should disbelieve his evidence, because Mr. Bacchus' evidence was of the nature that he gave. The jury are lay persons. They're seen men in a dark situation, or they're all together. The likely inclination would have been that they draw the conclusion that they're all in this together. So when
okay, so let me see if I understand you. You're saying that the judge should have told the jury that Mr. Green's evidence was an alibi, and that they should consider. But then I don't understand, what are you saying the judge failed to say that she ought to have said?
There was the issue of his alibi.
So she did relate that defense to
but she didn't
what
do it
Mr.
in
Bacchus said.
But she didn't do it in the context that when she warned them about Bacchus' evidence, reminding me, Your Honors, that the case for Green was that he wasn't there, he was brought back.
Right.
Mr. Bacchus is placing him there. And that he was with the others in a, for want of a better word, an enterprise together. Yes. But he said that I never knew any of my co-accused before. Does that sworn testimony of Mr. Bacchus now, is it such that the jury, being the finders of fact, would be entitled, yes, to consider it, but with a proper warning first that it is not able to displace and independently verify his participation unless there was other evidence to show that?
I think we understand your submission on this point, that the judge's evidence, the judge's summing up, that was not strong enough in order to establish that, given that Mr. Green's defense was an alibi, there should have been a stronger summing up in relation to Mr. Bacchus's evidence. Is that what you're saying?
Yes, Your Honor.
Yeah, okay. So can you go on to the next ground?
The next ground was related to the fact of the warning under section 137, in which we complain that for the warning to have been fair, because the warning normally advised the jury of the reason for the unreliability of the oral evidence allegedly attributed to the accused. But we said that for that warning to have been better able to assist the jury, the court would have to also inform the jury that, one, no accused should be under section 13.2. And I am saying it now that for the direction to have been balanced and fair, she would have to go on to inform them about the right against incriminating themselves because of what the police said, they all said. There was a lot of questioning and argument about what exactly, if the accused was told about his attorney and how he was to conduct himself and all of that. But the most important part was that no criminal suspect or accused had a duty to assist the police in building a case against themselves. The police in Barbados, it seems, are too given a free wheel to roll. And for the one, and it is a very contentious matter because sometimes men are convicted on oral evidence incriminating them because of what the police said. And lots of the statement that is attributed to him, yes, this is the door that I had, and this is the thing on the Silver Valley Wood. Even if his defense was saying one thing, the police have oral statements which were not acknowledged, taking a claim that he acknowledges involvement in this. So that judge never discussed with the jury or gave them any guidance. And I believe that it would have been better if during the summation, the court spent, if it's even just one aspect of it, to say that a person who's arrested do not have to tell the police and help them build a case against them, because that is the strength of the Crown's case in this. I can't speak about anybody else's plan, but I can say at least a parallel was easily available with one of the co-accused. Mr. Rambarran was taken from another place, and it is said that he agreed wholesale, lock, stock, and barrel. So that the case of, we cite Lam Chingmin versus the Queen, that's at paragraph 39 of my submission, that the privilege against self-incrimination is deeply rooted in English law, and it would make a grave inroad upon if the police were to believe that if they improperly extract admission from an accused, which was subsequently shown to be true, they could use those admissions against the accused for the purpose of obtaining a conviction. It is wrong. We go on further to say at 40, this is a Canadian case, R.V. Sinclair, that the right against self-incrimination and the right to silence cannot be eroded by an approach to criminal investigation, and in particular to custodial interrogation that would favor perceived police efficiency at the expense of constitutionally protected rights. The right to counsel and the extension of its meaning exercise cannot be dependent on an interrogator's opinion as to its opportunity or utility. The police are not.
We've seen this. What are you saying was done here in this case that ought not to have been done?
Well, she only gave them the warning as of the standard process. There was no assistance, and I made the criticism again that was that the purpose of a direction to a jury is not just disquisition on jurisprudence or to just say this is the law. A direction to a jury must be custom built to make the jury understand their task in relation to a particular case. Every single accused, in fact, one of the ladies said that she even wet herself the way how she was mistreated. And not once did the judge remind the jury of a higher standard of policing, a higher standard of conduct that is protected under our constitutional arrangement. I mean, the reason for its unreliability is one aspect, but it went hand in glove with explaining to the jury that all of these accused men, which at some point, the court repeated that they said that they were beaten and it's a matter for you. But it was a lacuna, a deafening silence from the court. And I wouldn't want to suggest that the court accepted that was a correct thing, but a little bit of help to the jury on that issue would have been helpful, especially in light that there were 6 non-nationals of a different place. The impression being that they come to Barbados with these very dangerous substances to destroy the deleterious effect on the society. The people, the jury are drawn from within the community. They're not aliens that live up in the sky and just look down and nod and say yes or no. They have views. Those views would have to be brought in line with a sense of fair play by the trial judge's input to them, to give them the guidance, to assist them in how to conduct and execute their task. I'm saying it was not satisfactory, that no effort was made to link any of the complaints made by the accused, Green, about his mistreatment in terms of how the court finally directed the jury on his defense to balance it, to put it in a contextual way that even if you say the police version is X and the accused is saying Y, there is a proper standard in a civilized society that we expect from our people who are charged with investigating. It is not to impugn the police per se, but I think it would have gone a long way to assist the jury how important the allegations were against the police. Now, it is still for the jury to find as a fact, but I did make the effort to, and it is winding up now, Your Honors, to stay, and it was from this same first ground where we use the principle of our discretion. Now, my colleague, Mrs. Rohan, chided me that it was really from the civil standard and whether that would suffice. But I believe guidance, in as much as it was in a civil case, that's the case of Associated Picture House Limited versus Wender Corporation. Because most of this is really about how the judge should deal with her discretion on the issue of the warning, on the issue, well, it was all about warnings. It was all about the judge's discretion, which would have been, the case would be made or break by whether the judge's discretion was exercised to such an extent and in such a way that one can say it was done properly. Because it is very difficult for the Court of Appeal and your Lord, your honors, to criticize a judge who saw, heard, and had a sense and a feel of the evidence and the witnesses to tailor-made the kind of way she speak and deliver to them. So that what was said was that a person entrusted with a discretion must, so to speak, direct himself properly. I'm not saying anything that is not known, but he must call his mind and attention to matters which he is bound to consider. The court would have been bound to consider some of what was raised by counsel in this application in terms of the strength, both for the issue of incriminating, not to help build a case against themselves, and also as it relates to how much further the issue as it relates to Mr. Bacchus. So we will rest on the submission as we had filed, Your Honor, and the responses that were in reply to the Crown submission.
Yes, well, thank you very much. I think what we do, we take a 10-minute break at this point, and then we will resume at, it will be a little bit more than 10 minutes, resume at midday, at 12.
the applicant Rambarran. It's at page, the document is the UN recommended guidelines for testing of cocaine. It starts at page 1157 of this record. And I wish to refer the court specifically to page 1171 of that document. The heading is sampling of items consisting of more than one package. The analyst should examine the contents of all packages by eye, which was done in this case, Your Honors. And then it goes on to say, if the powders are found to be the same, then the contents of a number of packages may be mesquite at page 4027 of the CCJ's paginated transcript. She says that the page 1100. My response in relation to the failure by Mesquite's failure to do that is this. Even though Mesquite admittedly did not test 3 planes, that is a requirement of the Forensic Sciences Center, and it is not a requirement from the UN SWIG drug protocol. The analyst did say that she complied with the UN, has been gracious to my friends, and my learners have admitted in their submissions that she had to comply with the protocol. And it's my submission that the UN protocol minimum standard, she complied with the minimum standard outlined in that protocol, because that protocol does not provide that you have to test from 3 planes. That additional requirement from the forensic exactly mean that the samples are unreliable, as my friend has submitted. In relation to that, I just wish to, my learned friend in her reply, the appellant in his reply to my submissions, stated that in relation to the risk of bias, stated that the applicable scientific protocols frowned on Mrs. Skeet's participation at the point of sampling. I wish to point out to the court that the protocols, which is the UN SWIG drug protocol, actually provides for sampling by the analyst and not by anyone else. So Ms. Skeet being involved in the sampling was not actually against the UN SWIG drug protocol. And it's my submission that neither was it against the Evidence Act. Because even though the Evidence Act says that the sampling has to be done by a police officer, which was done in this case, my submission is that it does not preclude the presence of other persons being there when the sampling is done. It's my submission, Your Honors, that the evidence of Mesquite was not demonstrably unreliable, as my learned friend has contested. Yes, there were some inconsistencies between her evidence and the evidence of Sergeant Hope and the evidence of the photographer, but it's my submission that just like any other discrepancies, the judge gave the appropriate warning and it was available to the jury to determine how they would resolve those discrepancies, whether they believed the witness, Marcia Skeet, whether they believed another witness, and in so doing, Your Honors, they would determine what they made of Mesquite. So it's my submission that the evidence of Mesquite could be relied upon by the jury to convict the appellants, as was done. I wish to address ground 4, which is the ground that the expert direction needs to be amended. My learned friend, in her oral submissions to this court this morning and in her written submissions, urges the court to adopt the some of the guidelines that have come out of the New South Wales, and also the court should pay credence to the guidance from the UK. In relation specifically to the guidance from the UK, Your Honours, Council has pointed the court to the Law Commission report and an article by Edmund and Roberts, which discusses that article. In relation to the article, Your Honours, I wish to draw the court's attention to pages 542, and there's a thing called judicial competence.
That's 542 of our record?
Of your records, yes. Your Honor. The Law Commission from the UK Law Commission had recommended that the common law test as it relates to the expert evidence be abolished and that it be replaced by a reliability test. In discussing the reliability test, the authors of the article stated, if the Commission's proposals are to be effective, trial judges will need to demonstrate something more than a passive or rudimentary understanding of these matters. Determining whether opinion is based on an unjustifiable assumption, flawed data, or a hypothesis that has been subjected to insufficient scrutiny requires in those responsible for making such evaluative judgments an ability to engage critically with the basis of the opinions being proffered. So much appears to be acknowledged in the report, which suggested that judges do not need to be trained to become scientists. They merely need to be trained to be critical consumers of the science that comes before them. Confidence from the provision of the kind of limited training implied in the report will equip trial judges with anything more than a capacity to comprehend some scientific propositions or identify a few potentially meaningful questions may be misplaced. So clearly the authors of the report acknowledge that the judges will need more than just rudimentary understanding of the certain area of expertise. And the authors of the journal article are saying that they are doubtful that the training that the Law Commission suggested would actually have any effect on the knowledge of the judges. I say that, my lords, your honors, in support of the submission which I have made in my written submission, which is at paragraph where's the court's indulgence? #98 of my submissions. And in paragraph 98 of my submissions, I said that the type of direction that has been suggested by the appellants or the applicants would mean that trial judges themselves would have to be experts in an infinite number of areas. Of course, I don't mean experts to the extent that they have to go and study the same amount of time as the actual expert. But of course, to conduct the sort of analysis that my learned friend is suggesting would mean that the expert themselves have to have more knowledge than just the common person. They would have to have, as the authors of the article indicated, they would have to demonstrate something more than a passive or rudimentary understanding of the area. And as I pointed out, your honors, this case involved drugs. So the question was whether or not the substances that were seized were a controlled substance. But as your honors would be aware, the areas that we have experts in criminal law is an infinite number of areas. There may be psychologists, there will be pathologists, maybe accountants if it is a case involving theft. There's an infinite number of areas that could require an expert. And therefore, an infinite number of areas which would require the judge to have more than just a passive or rudimentary understanding of the matter. And in fact, in the UK, following the Law Commission report, the UK government actually declined to accept any of the recommendations for several reasons, one of these being what I have just said to the court. So the UK government actually declined to follow the recommendations, and still the common law is still what is the position in the UK. And in fact, in the Law Commission report, which actually acknowledges the shortcoming of the judge in relation to the expert and the reliability test which they propounded, the Law Commission report actually stated that they would suggest that there be a procedure by which the judge can call their own expert to advise them on how they should apply the reliability test, which of course in itself acknowledges that there are some limitations to the judge. Judges study the law, they know the law, but of course they cannot be expected to know everything under the sun and have more than a passive or rudimentary knowledge in all the areas that may come before the court. According to the court's indulgence? Yes. Yeah. Your Honors, I stand by my written submissions, and unless the court wishes to have me advise on anything in particular, those are my submissions, and I will pass to my learned friend to respond to the submissions filed on behalf of Gavin Green.
Before you pass over, there was some criticism made of the role that Nurse and Skeet played, and it was suggested that there were contradictions in the evidence that the judge had a duty to bring to the jury's attention, and that was not sufficiently done.
Sorry.
I think it's
Sorry, Your Honor, I lost you, Your Honor. I didn't hear the question from the beginning. I lost the part of the question there.
Yeah, I think the criticism generally was that the direction to the jury around the sampling and the alleged contradictions, etc., in the evidence of Skeet was not sufficiently customized for this case. How would you respond to that? Because you responded in particular to the compliance with the UN protocols. Yes?
Yes, Your Honor.
But the criticism was a little broader. It suggested that the general inconsistencies that were brought out in cross-examination were not sufficiently addressed by the trial court judge. I'm leaving aside the no case submission aspects for now. How would you respond to that?
Is my submission, Your Honor, that the trial judge adequately dealt with that when she gave the discrepancy and inconsistency direction. The evidence of Mesquite in my submission was consistent, but it was at odds with the evidence of Mr. Hope in terms of how much was sampled. Mr. Hope, of course, was not the expert. Mesquite was the expert, and she gave evidence consistently as to what was sampled and how it was done. And it's my submission, Your Honors, that the discrepancy and inconsistency direction would adequately cover the issue which has been raised by the applicant. So if the jury is told that they should determine what is the reason for the discrepancy, if they find that the one person is mistaken, then they can sift through their evidence and accept what they believe. If they accept the evidence of Mesquite, then they could accept her conclusion. If they did not accept the evidence of Mesquite, then they should reject her conclusion, which is what the jury were told
Maybe I think one of the criticisms was that also section 132C was not followed, the steps. Could you say something about that? Apparently, it is required that a police officer shall take the samples in the presence of the accused and a justice of the peace. The evidence shows that that happened?
The evidence, Your Honor, was that the samples were taken in the presence of the police, by the police, in the presence of the justice of the peace, but the container was only initialed by the police and not by the justice of the peace.
But also in the presence of the accused, correct? Also in the presence of the accused, correct?
I believe so, Your Honor.
Okay, and then apparently this has to go into a container. The justice of the peace has to sign and initial the container. That didn't happen. And then it has to go to the commissioner of police, and the commissioner of police refers it to an authorized analyst. But I don't think that that is what, in practice, what happens. Is that so?
In this particular case, the only thing that did not happen out of that sequence was that the justice of the peace did not initial the container.
But Ms. Keith was there when the samples were taken, and so that she took them right and checked and tested them right there and then. It didn't go through a commissioner of police and so forth, correct?
No, Your Honor. She left after the samples were taken, and they were submitted to her through the police officer and through the commissioner of police to her department to be tested. So she did not take them away with her.
Oh, okay. So you say all these steps were followed except the signing and initialing of the container by the justice of the peace.
Yes, sir.
Okay, thank you.
Counsel, just one matter. I got the impression, listening to Ms. Sicharan, that her complaint was that the evidence of mesquite after 3 days of rigorous cross-examination and after many inconsistencies were shown up, this is how I understand her submissions, the evidence was severely discredited and manifestly unreliable. And I understand Mr. Rambarran's to be making the submission that the judge ought not to have allowed this matter to go at all to the jury, that the judge ought to have upheld the no case submission. And I wanted to know what you say about that, because I noticed your observation on it earlier was that the judge gave the necessary directions. But before you even get to that, what can you tell us about the no case submission and mesquite's evidence?
Yes, Your Honor. I bear in mind what my learning friend said earlier, that I was not present in the courtroom and she wished there was a videotape. But the only thing I have is the transcript. And my reading of the transcript, Your Honors, does not reflect what counsel for the appellant or the applicant has stated is the state of mesquite's evidence. From my reading of the evidence, Your Honors, mesquite was consistent throughout her evidence. Mesquite stated that she tested all of the packages. I'm just saying this because these are the contentions that the applicant has with the evidence of mesquite. So firstly, they're saying that she did not sample correctly because she did not sample the correct amount of packages. Mesquite stated in her evidence over 3 days, she stated on 26 occasions, I state this in paragraph 29 of my submissions, on 26 occasions over the 3 days, she stated she sampled all of the packages. She explained why the sample populations on the certificate of analysis do not correspond to the number of packages, and she explained that this was because she did the composite sampling. That's another complaint made by the applicant in relation to the sampling process. They're saying that mesquite, there's no scientific basis on which mesquite could take composite samples, I referred the court earlier to the protocol, which provides that the powders can be combined once the analyst has examined them by eye and found that they're all the same. So it's my submission that that complaint also is baseless. One of the other complaints, Your Honors, is that the analyst peer-reviewed herself. Ms. Skeet, throughout her cross-examination on at least she said it on 16 occasions. That's in paragraph 48 of my submissions. She said on 16 different occasions that she did not peer review herself. Her role on the bench was that she was the peer reviewer. Ms. Skeet stated that the initial tests were conducted by another scientist, Debbie Ann Nurse, and she reviewed the results, and in some cases she performed the tests again. So she was the peer reviewer on the bench. So it's my submission that that complaint also is baseless, where it's saying that the work was not peer reviewed and that she attempted to peer review herself, because she made it clear that she was in fact the peer reviewer.
Does it make a difference if a witness says something 16 times, or?
It does not, Your Honor, but I said to emphasize the fact.
Yeah.
I said to emphasize the fact that she was consistent. She said it over and over and over. She didn't just say it once.
Okay, good.
I'm trying to remember the other complaints.
President, I think you're muted.
Yeah, President muted. He said something.
Yeah, sorry. Is there anything further that you need to tell us, Ms. Delaney? Can we call on Mr. Watson now?
Yes, sir. Just in answering, Your Honor, Rajnath Lee, just to say, Milady, Your Honor, that is my position, is the position of the respondent, sorry, that the evidence of Ms. Skeet was not in a disarray, as has been characterized by the applicant, and that the case was a fitting one to go before the jury. And as such, the learned judge did not err by failing to upholding no case submission.
Thank
Those
you,
are my submissions.
Yes.
Yes.
Okay, thank you. Mr. Watson?
Yes, good day, Your Honors.
Yes, good day.
The respondent continues to stand by the submissions made, but we also recognize that the appellant in relation to Mr. Gavin Green changed his submission in relation to ground one as it relates to the response to our initial submissions. And indeed, this honorable court has also observed that is the position that the appellant, has taken. I wish also to add that the case, the Queen against Chima.
Against whom?
Chima, C-H-E-E-M-A.
Yes.
And that is, Your Honor, is one of the cases that my friend in relation to Gavin Green has filed. Now, I'm not certain if my friend has only done a perfunctory reading of that, but in reading that case thoroughly, one recognizes that it doesn't particularly help my friend as it relates to his submissions. Because even if we were to look at, and I'm using the citation 1994 1 All England Report at 639. And even if we were to immediately look at that particular page, we would see that the holding of the court in that matter directly accords with what our case is. And if we could just query and just briefly to read one or two excerpts on it. There was no rule of law which required a full corroboration direction in respect of a co-defendant's evidence. All that was required when one defendant implicated another in evidence was simply a warning to the jury of what might very often be obvious, namely that the defendant witness may have had a purpose of his own to serve. The learned trial judge in this matter directed the jury on at least 5 occasions, and those occasions we have noted in our submissions. They are page 17, page 419, page 516, and page 521. And the last one at page 521 was given just before the jury retired, so that that direction, Your Honors, must have resonated with the jury. There's also one other excerpt that I would wish to draw upon from the same case, Your Honors. And that is at page 644. Sorry, 645. 645. And this is where the court in this particular matter was examining a number of authorities. And I wish to read from that same page. The court says, however, between the Queen and Barrow decided in 1934, the Queen and Garland decided in 1941, this court gave a decision to the contrary effect in the Queen and Barnes, the Queen and Richards, and the head note of that case reads in part, where prisoners are tried jointly and one of them gives evidence on his own behalf, incriminating a co-prisoner, the prisoner who has given the incriminating evidence is not placed in the position of an accomplice, nor does the rule of practice with regard to the corroboration of an accomplice apply to such a case. The rule applies only to witnesses called for the prosecution. So that, Your Lordships, that is the witness, Mr. Christopher Bacchus, was not a witness called for the prosecution. In fact, he was given evidence on his own behalf. So that is the distinction which ought to be drawn from this particular case. So that, Your Lordships, when one considers this same case, the Queen and Chima, and when one considers what the trial judge did in relation to giving that particular direction, one can see no fault. One can see no fault in the manner in which she directed the jury in relation to any cooperation which may have been required, notwithstanding that she was not even bound to give it in the first instance, considering that cooperation requirement has been abolished in this jurisdiction. But because of fairness, the learned trial judge went to that extreme, or to that extent, to give that particular warning and to give it some 5 times to the jury. My friend also complained that the learned trial judge acted outside of her discretion, and this is how I read it. When my friend drew on the case of Associated Picture Houses against Wensbury Corporation, and I would wish to refer to it as Wensbury unreasonableness for ease of reference. What I do recognize in Wensbury is that Wensbury was a civil matter, and it dealt with an executive act and not a judicial act, and it dealt with jurisdictional errors where Lord Green, Imar as he then was, where he sought to catalogue a number of jurisdictional errors, including ultra vires, acting in bad faith, etc. And it was even decided that the person who is alleging that the executive authority, that person is acting unreasonably, that the person who is alleging this must do more, or must show why or how that authority has acted unreasonably. It is just not enough to say that this person or this authority has acted unreasonably. And even in that particular case, the court was trying to grapple with what then are the powers of the courts in that instance, and whether they can interfere with an act of an executive authority, and the parameters in which they can interfere with that particular act. Naturally, it's some part of the law. It's some part of the law. Yes, sir.
For my part, I think you can take it that we are all very familiar with Wensbury and the limited application that it would possibly have in this case. Yeah?
Very well, Your Honor. I thank you for your guidance. That said, Your Honor, I would invite this honorable court to find that the learned trial judge in this matter acted reasonably, acted within the four corners of the law, and did not bring her mind to any irrelevant considerations. Your Honors, we continue to stand by our submissions that we have filed.
I understand your first conclusion is that we should refuse the application for special leave, and if we don't do that, that we should dismiss the appeal.
Indeed, Your Honors. That's our application, Your Honors.
That's the end of your submissions, Mr. Watson?
Unless I can, do you have any further assistance? Unless there are any other questions for me, Your Lordships?
No. Ms. Cicheron, is there anything that you wish to say in response?
Your Honors, just with your leave, just to say that we continue obviously to rely on our reply filed in this matter. But on a matter of law, I understood my learned friend to be saying that the common law is still what obtains in the United Kingdom, and that the Law Commission report on expert evidence in criminal trials the recommendations set out therein were not accepted. I would just wish to respond to say that the Law Commission's report was based in a particular context, which had to do with whether or not there should be adopted in England an enhanced test of admission into evidence for expert evidence. And the Commission drafted a bill, a proposed bill, which was not passed in the House of Commons. I would wish, with your leave, to send, after this matter is concluded, the link to the introduction by Professor David Omrod QC as part of the Law Commission website. And it simply says that they've made several recommendations in their report, which was published on the 22nd of March 2011. And in the report, they recommended, among other things, a new admissibility test for expert evidence. There is on part of that page 2, a heading called Result, where they said that the Ministry of Justice responded on the 21st of November 2013, indicating that it did not intend to act on the majority of our recommendations at this time. They said, however, that they had achieved a great deal by other means, including that the Criminal Procedure Rules Committee had adopted parts of the Law Commission's report when it dealt with expert evidence, and that there were other parallels which had formed part of the law in England thereafter. But simply to say, Your Honours, and while I would wish you...
Before you finish, does Barbados have all of that supporting legal, quote-unquote, infrastructure?
No, Your Honor, the point I was about to make is that this is a question of this court respectfully setting a best practice. So while in England we have, and ideally we would have liked to have here as well, criminal procedure rules, the Law Commission report was setting out a particular test there, but what we are asking this court to do is to examine the question of what directions a judge should be giving a jury in assessing an expert's evidence. We accept that there may not be a scope for introducing an enhanced reliability or admission test when it comes to expert evidence, but we were relying on the Law Commission report in the context of the wider dispute about how to treat expert testimony generally and how to assist the jury in dealing with that issue. It is just for me to say, Your Honours, that in our respectful view, we badly need the guidance in these types of cases. And unless you wish to hear me further, that would be our reply on behalf of the applicant Rambarran.
Yes, thank you. Mr. Gordon, is there anything that you wish to say?
I'll just say that we wish to adopt those arguments of the applicant Rambarran as it relates to the testing methodology of the grounds file, the certificate, the critique on the witness Mesquite, those areas which are common to my client, in as much as we didn't file a separate ground for those, we'll adopt those if it is possible at this stage, Your Honours.
Yeah. Okay, thank you.
That's
okay,
my
well,
submission to
yes, thanks. I'm going to ask you to remain online. The judges will take a very short break, and then we will come back to you and let you know how we are going to deal with this case. So just remain online for the time being.
Grateful.
Please.
Okay, are all the...
Is Justice Witt with us?
I think so. Oh no, not as yet. Council, we are just awaiting Justice Witt to rejoin the call.
President, I think Justice Witt is trying to call in.
Right.
I'm not sure who has to let him in, but I think he is trying to call in to join us. I think he may be in now.
I think he is.
Yes. Justice Witt, you're with us, correct? You're on mute.
I am, yes.
Okay, great. Okay. So I think we're all here, and I am seeing counsel. We've read all the submissions in this matter, and having heard the oral submissions today, the court is disposed to disallow the grant of leave, special leave, and we will give brief written reasons in due course. So the application is denied. Madam Deputy Registrar, would you please bring the proceedings to an end?
Thank you, President. This court stands adjourned. Thank you.
Thank you.